Okay, we will call the meeting to order. Welcome, everyone. Welcome to meeting number 59 of the House of Commons Standing Committee on Finance. Pursuant to Standing Order 108.2, the committee is meeting to study the coming into force of Bill C-208, an act to amend the Income Tax Act, transfer a small business or family farm or fishing corporation. Given the ongoing pandemic situation and in light of the recommendations from health authorities to remain healthy and safe, all those attending the meeting are to, seeing as it's the first time I guess we've all met in a committee room, I know me for 16 months, we're to maintain the 2-meter physical distancing. We must wear a mask when circulating in the room, and it's highly recommended that a mask be worn at all times. I don't think members can be expected to. And we must maintain proper hand hygiene by using the hand sanitizer at the room entrance. And so I'll try to enforce those measures, but I don't think enforcement will be necessary. And I know there's only one staff per party allowed in the room. So I thank members for their cooperation. And by video, in our first hour of this session, we have with us Mr. Philip Dufresne, who's the law clerk and parliamentary counsel and been before the committee a number of times. Welcome. And with him is Michelle Bedard, deputy law clerk and parliamentary counsel, Office of the Law Clerk and Parliamentary Counsel. So welcome to the both of you. I imagine you have an opening statement. There was considerable controversy and a number of us had said that I think MPs believe Parliament is supreme, and there was a little difference of opinion, I think, between us and Department of Finance and maybe others. So we'll turn to you for an opening statement and then we'll go to questions.
Merci. Merci beaucoup, Monsieur le Président, distingués membres du comité, de nous avoir invités à comparaître aujourd'hui après la publication d'un communiqué de presse le 30 juin.
Thank you for your invitation to appear today following the Department of Finance Canada's announcement on next steps for Private Members Bill C-208. And the clarification issued by the government yesterday replacing June 30th's release. As the law clerk and parliamentary counsel for the House of Commons, I am pleased to be here today to address any questions that the committee may have with respect to this bill. My office provides comprehensive legal and legislative services to the Speaker, the Board of Internal Economy, the House and its committees, members of Parliament, and the House administration. As counsel to the House, its committees and members, we serve the interests of the legislative branch of government and provide similar types of legal and legislative services to the House as the Department of Justice provides to the government. I am accompanied by Michelle Bedard, Deputy Law Clerk and Parliamentary Counsel, Legal Services, and I hope that our answers will help the committee.
208, I want to take a few moments to highlight the rules applicable to the coming into force of legislation. The same rules apply equally to legislation implementing tax measures. Enacting new laws and amending existing ones is a process that culminates in a legislative text receiving royal assent. However, a distinction must be made between on which a legislative measure is enacted by Parliament and the date on which it comes into force. A bill becomes law after it has been passed by both houses in the same form and has received royal assent, but its provisions will produce their effect and become enforceable only when they're brought into force. The Interpretation Act, which applies to all federal legislation, contains the provisions governing the coming into force of statutes, including the timing of that coming into force. Generally, a statute will come into force either on the day of assent or on another date as provided by the legislation itself. The other date could be a specific day set out in the Act, or the Act could leave it to the government to determine the date of the coming into force by an order in council. If no coming into force provision is included in an Act, the default rule found in subsection 5.2 of the Interpretation Act applies, and the entire Act comes into force on the day on which it receives royal assent. Je vais maintenant dire quelques mots qui portent précisément sur la...
I will now say a few specific words about the implementation of tax measures. Governments will from time to time implement proposed legislative changes respecting taxation. For example, for new capital gain inclusion rates or new GST rates before their formal legislative enactment. The actions of taxpayers will then be influenced by the proposed measures that are oftentimes already implemented administratively by the Canada Revenue Agency in anticipation of the subsequent legislative enactment that would have retroactive effect to the date the proposed legislative changes were announced. House of Commons Procedure and Practice summarizes this practice as follows, and I quote, "It is the long-standing practice of Canadian governments to put tax measures into effect as soon as the notices of the Ways and Means motions on which they are based are tabled in the House of Commons, with the result that taxes are collected as of the date of this notice, even though it may be months, if not years, before the implementing legislation is actually passed by Parliament. Implementation of the tax measures often starts when their announcement is made, including by the tabling of a Ways and Means motion, but is always contingent on the tax measures being ultimately enacted by Parliament."
An act to amend the Income Tax Act to transfer a small business or family farms or fishing corporation received royal assent on June 29, 2021. The bill does not contain a coming into force or commencement provision, so in accordance with subsection 5.2 of the Interpretation Act, the date of coming into force is the date of royal assent. This means that the new provisions apply as of that date, in this case, June 29, 2021. There is nothing unusual about this. The government's June 30th announcement stated that the government proposed to introduce legislation to clarify that the Bill C-208 amendments to the Income Tax Act would apply at the beginning of the next taxation year, starting on January 1st, 2022. Yesterday, the government issued a new statement replacing the June 30th news release and affirming that, as Bill C-208 has been passed by Parliament and received royal assent, it has become a part of the Income Tax Act, and the changes contained in Bill C-208 now apply in law. The government also clarified that it intends to bring forward amendments to the Income Tax Act that honor the spirit of Bill C-208 while safeguarding against any unintended tax avoidance loopholes may have been created by the bill. Because the bill is now law, if any changes are to be made to it, it will require new legislation. Such new legislation could provide for any amendments to the Income Tax Act to apply retroactively, including applying them to events that take place before the day on which the new legislation comes into force. And with that, I would be pleased to answer any questions you may have. Merci. Thank you.
Thank you, Mr. Dufresne. The first round, we'll start with Mr. Kelly, followed by Mr. Fragascadas, Mr. St. Marie, and Ms. Matheson. Mr. Kelly.
Well, thank you so much, Mr. Dufresne, for coming to appear today and for the clarity that you've brought to this issue. So let's just get right to it. Bill C-208 became law on June 29th, correct?
Yes.
All right. Is there any possible explanation that you could imagine why this government would say otherwise in its June 30th press announcement?
I can't speculate as to intentions. I've mentioned the two communiques, the one on June 30th, and it has been replaced now by the communique that was issued yesterday.
Right. Right on the eve of a really an embarrassing meeting that the department would have to go through. They backpedaled the June 30th announcement. Have you known any precedent for a government to refuse to implement a law upon it receiving royal assent, such as has been the case with this bill?
Well, this was an unusual situation in the sense of a statement following coming into force and talking about a different coming into force date. There have been situations where the government has announced legislative measures, tax measures, and has implemented them pending legislative parliamentary approval. But this current situation with was not one that we had seen before.
Okay, so no government has ever done this. You just put out an announcement announcing that they are not going to implement a law passed by Parliament.
Well, as I say, this communique was issued. It announced the government's intention to introduce new legislation to change the coming into force date. That's not something that we had seen before.
Right. And your office has been very busy over this last year and a half or so. We have seen this government defy Parliament, defy orders of committee, You've been present at this committee for this issue. Are you concerned by the pattern of governments or any government ignoring the will of Parliament?
I think what I've stated to this committee is that Parliament is supreme. Parliament has privileges and has fundamental authority, and I've taken that position, and that's an authority that Parliament has to exercise responsibly, and that continues to be my position.
And again, I thank you for your vigorous defense of Parliament. In a parliamentary democracy, Parliament has to have the last word on public policy. We have a government that has ignored Parliament by refusing to implement this bill when it received royal assent, on the heels of actually suing the House of Commons and naming the Speaker of the House in seeking court approval to defy Parliament. This is all within the last few weeks. Can you comment on a pattern emerging with this government? This is also on the heels of the defiance of orders at this committee.
I provide views and advice to committees on issues as they arise. You litigation, and the Speaker has informed members that he has instructed my office to respond to that litigation, and we are doing so. And as indicated, I've appeared before this committee to advise on the powers of the House and on the supremacy of Parliament and parliamentary privilege as a constitutional matter, and that I will continue to do so.
So, responsible government was achieved in Canada before Confederation. Really, since 1858, has any Canadian government besides this one openly and blatantly refused to implement laws passed by Parliament?
I will comment on the authorities of the House, and those authorities are fundamental, and the House has exercised them, and I will support the exercise of those authorities.
Yes, and we thank you. We thank you for that, and for your defense of Parliament, Mr. Chair. Have I got any more time, or are we
time for one more question?
All right. So the again, what do you is the backpedal that we saw yesterday? I would suggest that there are still questions that remain. There is still an intention upon this from this government to not implement the bill as passed by Parliament. What further steps do you think the government needs to take to assure Canadians that it will actually follow through, implement this bill, and respect the will of Parliament as expressed through its democratically elected members and senators?
Well, I think that the government has issued a statement yesterday. The committee, as I understand, will be hearing from further witnesses and can determine if it's satisfied with the clarification that it has received. But the government has issued a statement indicating that it recognizes the bill is in force and proposes to introduce amendments down the road.
Okay, thank you.
Thank you both. Mr. Fragas got us 6 minutes, followed by Mr. St. Marie.
Thank you, Chair. Good to be here in Ottawa after a lot of time. Nice to see colleagues in person once again, and hope everybody's kept healthy and safe, and hope everyone's loved ones are okay too. Many thanks to you, Chair, along the way. I know these are the final set of meetings I think we'll have as a Finance Committee with you at the helm, and it's been absolutely great. Just a wonderful experience working with you, as I've told you over the years, and to the staff behind the scenes too, here at Parliament and our own staff. Thank you very much. This committee's been very active over the past year and a half without any stops, and that continues. Mr. Dufresne, you've answered it, I think, but I want to be crystal clear here. The press release that we saw yesterday, is that consistent with the view that Parliament is indeed supreme and that Bill C-208 is in force? The press release recognizes that, I think, but could you elaborate?
I think the July 19th press release does clarify the government's view that is certainly consistent with the fact that the bill is in force. So we see this recognition. The bill is in force as of royal assent. In this case, there was nothing unusual with there not being a specified coming into force date in the bill, and so that's now been clarified, and that the law applies. And the government is indicating its intention to introduce future legislation to address certain matters, and that is something that we've seen before in terms of practices, in terms of announcing future measures and confirming that they're conditional to the parliamentary approval.
Thank you very much. My friend and colleague, Mr. Kelly, did not expand on it. I don't think he had time, but he put forward a claim that the government is not, by looking at yesterday's press release, in his view, the government is not serious about moving forward with C-208. I'm not sure where that observation comes from. I look at the press release. I looked at it closely. And it does say, and you put this in your testimony, sir, you said that, as the release identifies, that unintended consequences that could come about with C-208 will be addressed. That is not inconsistent with the recognition that this is law and that Parliament is supreme. Would you say that's accurate?
That's the government expressing its concerns. I was paraphrasing the government's concerns with the bill as it stands in law, and its intention to introduce future amendments on that point. So that is consistent with practice that we have seen, and it clarifies perhaps the ambiguity in the June 30th statement, which mentioned the lack of a coming into force date and indicated that amendments would deal with coming into force date. So that's now being clarified and replaced with the statement from yesterday.
I hear you. So in other words, with the government saying that they will that they will move forward to ensure that possible unintended consequences of the bill will be addressed, that does not circumvent the will of Parliament. That does not ignore the will of Parliament on the matter. Governments can do that and still be in line with Parliament's view.
Governments can express their intention to introduce subsequent legislation, and that is subject to parliamentary approval.
Okay. I only have about a minute and a half left. I wonder if you could just one more time go through the difference between, not difference per se, but you pointed to a distinction between royal assent and a coming into force of a particular bill and what the Interpretation Act says. Based on your, and please elaborate, but based on that testimony that you gave, it sounds like the date of royal assent is usually the default position. Is that an accurate understanding?
That is accurate. The provision reads: if no date of commencement is provided for in an act, the date of commencement of that act is the date of assent to the act. So that is the default provision, in the sense that if there's no other specified coming into force, then it comes into force on the date of royal assent. There is possibility to provide a specific date in the act itself, which wasn't done here. There's also the possibility to give the government the ability to set the date by order in council, usually in a situation where the government needs to be satisfied that it's put in place necessary mechanisms to do so.
Yeah, and I, with a final point, Mr. Chair, I voted for C-208. I think it's a necessary measure. A number of Liberals voted for C-208 as well. You are Parliament's lawyer, Mr. Dufresne, if I can put it that way. Once again, are you satisfied that yesterday's press release makes clear that C-208 is recognized by the government as a bill that that will be put in place?
I'm satisfied that in a release yesterday, the government has recognized that C-208 is in force and has expressed its intention to introduce future amendments.
Thank you very much.
Thank you, Mr. Fragascatis. Mr. St. Marie will be followed by Ms. Matheson. Gabriel, the floor is yours. I pretty need binoculars to see you down there, but I see you. Go ahead, the floor is yours.
Bonjour, bonjour, Wayne.
Hello, hi Wayne. Hello, Mr. Dufresne. Hello, Mr. de Bédard. And I'd like to thank the entire team of the committee. It's really great to see all of my colleagues in person. Even though it's the beginning of the construction holiday, well, when you've got to go, so to speak. And I will start with a brief comment. I was very pleased to see the announcement yesterday, which basically was a 180. And I think that the announcement that this committee will be sitting perhaps had an impact on the department to ensure that ultimately it would accept the legislation. As we saw in the Globe this morning, I would like to thank all members of the committee, particularly the chair. I think we really made a difference here. Mr. Dufresne, we've spoken about the powers and authorities of the House and its authority. To what extent was the House's authority not respected, and how was that ultimately corrected in the second press release, in your opinion? Thank you very much. Well, I think the issue with the initial press release was that it underscored that C-208 did not have an implementation date. That was mentioned in the first paragraph. And ultimately, it was concluded that the government had the intention of introducing new legislative measures to clarify that these amendments would apply at the beginning of the next fiscal year. That was the aspect that was more surprising, or perhaps that could have led to confusion, because it gave the impression that the absence of a date in the legislation was a gap or something to be clarified, but that's not the case. The Interpretation Act is very clear. And that ultimately raised the question, well, is the intention here to ultimately have the bill only be brought into force later? The new press release replaced that and indicated that on the first point, the bill is in force, and on the second point, that the legislative amendments considered by the governments will target specific points, but not the date of entry into force. Thank you, that's very clear. Now, in your opening remarks, you stated that you are counsel to Parliament, elected officials, and so on, and you said that that's similar to the role of the Department of Justice for government. If I may editorialize a little bit, I'm quite surprised that the Department of Justice stated that if there's no date, the government gets the date whenever it wants. I think that the government, the Prime Minister and his team said to themselves, well, we don't entirely agree with this bill, so we're just going to try our luck. Because I don't think the Department of Justice would have misled the government in this way, which is why it's so important that this committee scheduled an emergency meeting today, and why, in my opinion, it's so important that we got the new press release. Now, Larry Maguire may want to correct me, but in a Radio-Canada article from yesterday, it stated that first reading of Bill C-208 was carried out on February 19th, 2020, but now we're already in 2021. So the author of the article said that it's been 527 days that it took between first reading and the moment when the legislation finally came into effect with royal assent. So, Mr. Dufresne, could you remind us here at the committee, and for those listening, what are the regular stages that a bill must go through? And at which of these stages could the government or its representatives, during these over 500 days, at which of these stages could the government have made proposals to make the bill comply with its goals, as it's saying it's going to do in future legislation? Thank you very much. Well, in order to pass, the bill needs to go through 3 readings. First reading in the House, where there is no debate, then second reading, where there is debate on the principle of the bill, then it's referred to committee. There is debate at committee and can be amended at committee. Then the bill is sent back to the House. And then there's a vote at third reading. And subsequently, the bill is sent to the Senate and needs to go through 3 reading stages at the Senate as well. And then it receives royal assent. Therefore, during these stages, as it's going through the House, the government or members of the government can make amendments or propose amendments. Thank you. That's very clear. So we see that there are stages in the House and in the Senate where if the government doesn't think that the bill is perfect, well, it can propose amendments. And yet, in the first press release, that was the reason the government gave for not wanting to implement the bill immediately. But yet we see that there was a 527-day period where at every stage the government could have made these amendments. We are in a minority government. We need to collaborate, and we see that here at the Finance Committee. We've seen that. We see that that's the beauty of a minority government that works closely with all MPs. And yet, to my knowledge, the government or its representatives did not propose any amendments. I think they were asleep at the switch. They had 527 days to propose amendments. I would also remind listeners that in Quebec there are similar provisions. There are signposts or methods to protect against tax evasion. It's been working well. The government had all the time it needed to draw inspiration from that. It could have considered all of this. It could have invited experts to committee. I recall at committee, the Liberals did not bring forward any of their own witnesses. In fact, to my knowledge, they did not make a single amendment or propose any amendment. I really think that they missed the boat. I'm pleased to see that they ultimately changed their mind yesterday. I'd like to thank you, Mr. Dufresne, as well as your colleague, Mr. Bédard. I will stop there.
Thank you, Mr. St. Marie. We'll go to Ms. Matheson. Will be for 6 minutes, and then that'll be followed by Mr. Berthold and Mr. Maguire on a split time. Go ahead, Ms. Matheson.
Thank you, Mr. Chair, and thank you to the members of the committee for allowing me to sub in. I will try to live up to the reputation of Mr. Julian. No. I appreciate hearing from you, Mr. Dufresne. You're very precise in your wording, as you know, we've seen often, and the precision of when you give that advice to parliamentarians, one would hope that the government would also respond with that same precision. But unfortunately, all of this confusion, of course, has come forward because they seem to have lacked the precision between the first press release and ideally the clarification of the second. But I did want to build off of what my colleague, Monsieur Saint-Marie, was talking about in terms of those different stages of a bill and how they specifically go through. And so, as he had mentioned, there were no amendments proposed at the committee stage of the bill. Everything was passed. It was passed through the Senate as well with no changes. So if the government were to bring forward this legislation or the amendments that they wish to see in a different piece of legislation, if the government stands as it is, the parliament stands as it is, it will go through those same processes, correct?
Yes.
Absolutely. And one would assume that because of the standing of the House of Commons currently in a minority parliament, that, you know, all things remaining the same, we would have the same result of the will of Parliament to pass the same legislation, one would assume.
That's more for you to assess than for me.
Okay. I know that we're sort of nitty gritty, but can you, is it common when the government says that they plan to introduce amendments that will honor the spirit of Bill C-208. Is there a precedent of explaining that? Is that language that's commonly used by government? Is there something more precise to that legally?
The formulation of the spirit versus the letter, and I think we hear this formulation from time to time. It seems, again, the government would be best placed than me to explain what they meant in the communique. But as I read it, it's a statement recognizing the bill is now in force, and the government intends to bring some amendments to deal with certain aspects of it, while keeping with the overall spirit, but addressing what the government sees as our concerns in terms of the bill as it stands.
So again, that's the will of the government versus the will of Parliament, almost in conflict, and their attempts to change legislation, which they have absolutely right to do within those amendments and introducing different parts of legislation. But ultimately, that still could potentially be in conflict with the overall will of Parliament, which you have said is supreme.
Well, I in the sense of indicating the government's intention to propose legislation, I would not necessarily see that as a conflict with the will of Parliament, in the sense that Parliament has not expressed its will on that proposed legislation. I think what is being stated is there's an intention to bring forward a bill, and then that bill would be subject to debate and approval by Parliament. Okay.
If you could just, Monsieur Saint-Marie had talked about the length of time this piece of legislation took to come through. Was that sort of I know that all pieces of legislation are different, schedules are different. Was that sort of an average, that 500 and some odd days, was that average for a private member's bill to pass through?
I don't have statistics of that nature. Bills vary in their scope and their complexity. The parliamentary calendar, of course, we've been in the pandemic situation, in a virtual parliament, and so it's been unusual times all around.
Okay. I ask because obviously there are rumors abound about an upcoming election. And yet within that second press release, that clarification, there was an indication that that legislation would come forward and be implemented by November the 1st. If there was an election during this fall session or time period, would that be possible for a government to pass that kind of legislation?
Well, if there is an election, there is a dissolution of the House, and so there is no ability for the House to consider legislation during that time.
Okay, but if they wanted to come back super fast, if there were changes potentially to the makeup of the House of Commons, they could now change that will of Parliament by bringing forward amendments as they wished.
The House will consider legislation in the composition of its members at any given time. So certainly, if the composition of the House changes, then that can have impacts.
Okay.
We'll have to end it there, and we'll go to Mr. Berthold for about 2.5 minutes, and then Mr. Maguire, and then Ms. O'Connell. Go ahead. Luke?
Merci, Monsieur le Président.
Thank you, Mr. Chair. I'll be very quick, Mr. Dufresne. I have several questions. Earlier, you mentioned that you had never seen a department the day after a bill was assented to or enacted. You've never heard of a department saying that they would enact the bill later because there was no date in it. Yes, indeed. So that goes against the will of Parliament and the rule of law? Well, it was something we hadn't seen previously. And as I mentioned, the fact that there is not a date in the bill, well, that's not something that is problematic for entry into force. Mr. Dufresne, earlier you said that a government can modify fiscal measures and implement them before modify tax measures, and that they can implement them, but that previously the bill needs to have been tabled in Parliament. Well, the practice that exists is that the government can announce measures that will be taken later, and then in some cases already start implementing them. But it's always subject to Parliament's ultimate approval of the measures. So in your opinion, would Parliament be violating the law if it announced now that it was modifying Bill C-208 and that it plans to amend it and that these new measures will be implemented immediately? Well, the government can't modify the bill, can't amend it. It would be the government, but the government can announce its intention to present legislative measures later, and in some cases can already implement these measures. But if it should do so, that is always subject to the approval and decisions of Parliament. What would happen if ultimately the bill decided not to implement Bill C-208 today, and if it did not subsequently receive the approval of Parliament? Who would be responsible? Given that there could be a change of government or an election, what would that mean for all the victims, people on farms or in small businesses? People who hadn't been able to carry out the transfer under Bill C-208. Well, the matter of knowing whether people and individuals have complied with the law as it exists, that's a matter for the courts. That would be something that would have to be dealt with before the courts at that point. So the government would have to say that it would make changes, and then perhaps those people would have to go to court. So that would create a lot of uncertainty for all owners of small businesses. It would create a great deal of ambiguity because people wouldn't have the details of possible legislation, wouldn't have details of what the government is planning to do. It would create a great deal of uncertainty. Another question. Between the two press releases, because we saw that the one yesterday said that the measures will be applied as of now, but there was also one on June 30th. So, in your opinion, if people took advantage of the great news of the adoption of C-208, will the people who may have taken advantage of that between the two press releases, will they be harmed? Well, this legislation has been applied since the 29th of June, and that has not changed despite the press releases. The June 30th release indicated the government's intention to make future changes, and yesterday's press release has confirmed that that is not the case and that the bill is in force as of now and has been since June, since the 29th of June specifically.
Thank you, Mr. Chair, and I want to thank you for the calling of this meeting and for our witnesses to be here today. Mr. Dufresne, in the case of the June 30th, 2021, your finance announced the suspension of this bill, 208. What legal authority did the department use to announce this tax policy change?
Well, my view is the bill was enforced. The bill is enforced since June 29th, and so what the communiqué did on June 30th indicated that the government intended to introduce future legislation to change that coming into force retroactively.
Certainly, and we have to agree that only Parliament can decide whether to give that legal effect to a proposal by government for tax measures to apply retroactively, and that's correct. I think you've already stated that.
Certainly, once the bill is in force, it applies until it's amended by Parliament.
So now that they've recused the statement from June the 30th by yesterday's press release, in a hypothetical situation, say they hadn't gone forward with yesterday's case and stuck to their original press release and unfairly delayed the implementation of C-208 until January 1st coming up, what recourse could Parliament take against the department? I mean, this is contempt of Parliament, similar to what the government has done by suing the Speaker. What if it were to happen again? What is Parliament's options here in regards to taking action against the department? Because the department put out the press release.
in terms of Parliament has the ability to do as it has done, which is to act as the grand inquest of the nation and to inquire into matters by the work of committees such as this committee and ask questions and obtain clarifications and if need be course corrections.
So yeah, I mean, so what happens to the, if the government provisionally collects a tax that ultimately never becomes law due to Parliament amending the bill or the bill never passing? I mean,
well, these are questions ultimately that can end up before the courts if there is a dispute with respect to what was done. Then the courts will look to the applicable law and precedents and will make their decision.
It'll be 5 minutes split between Mr. St. Marie and Ms. Matheson. Go ahead, Jennifer.
Thank you, Mr. Chair. It's good to be back here on finance. I'm going to start with a couple of comments before, Mr. Dufresne, I turn to you, but it's nice to see you again in less contentious, probably, committee than our last one at Health. But let me start where Mr. Maguire left off. He spoke in hypotheticals about any future legislation and possibility of it being retroactive. His pessimism is interesting, that he thinks we're heading into a majority government, that the government would have the ability to make whatever decision. So that's interesting. I share his optimism about our electoral success into the future. In terms of also his comments about any recourse from Parliament, well, it's interesting because the opposition can't seem to take yes for an answer. Finance Canada clarified just yesterday. Mr. Fragiscatos confirmed again that the issues of coming into a force were clarified. So it's interesting that the Conservatives once again can't take yes for an answer. And I'd like to also read into the record and correct some of the issues. Sorry, I hear a lot of chatter. I seem to be getting under the skin of some of the Conservative members. But I'd like to read into the record after Mr. Kelly's comments about his feigned outrage at the government. And it's interesting because I'm really glad he wasn't here prior to 2015. He can speak to his good friend, Mr. Fast, because let me read into the record the previous government. Here it says, the Harper Conservative government became the first in Canadian history to be found in contempt of Parliament. Even though it lost a court case and was ordered to comply, the Harper government nevertheless refused to share 170 times reasons and impacts for cuts with Canada's independent budget watchdog, mocking Parliament's right to control the public purse. So thank goodness Mr. Kelly was not in government during the Harper days, because I think he would be quite outraged with the actions of his party. So let's get back to then the matter at hand, now that we've seen the Conservatives and the complete hypocrisy throughout this process, and the fact that once again they write terrible motions when the government has to try to comply with their incoherent ability to write motions, and then try to feign some sort of, wrongdoing by the government. But getting back to this issue at hand, when it comes to the coming into force date, as I've already stated, the government and Finance Canada has clarified that. Mr. Dufresne, so getting back to you now that I've kind of clarified the hypocrisy from the Conservatives, getting to the substance of this, I tend to agree with you, and I spent a number of years on finance, and I thought your examples in your opening statement is the area I want to focus on, because I think it's quite right. Whenever I had done a Budget Implementation Act, the Fall Economic Statement, a budget, any tax provisions, the coming into force date was always the date it was tabled in my experience, in terms of the publication of it, because they didn't want any, the government, rightfully so, didn't want any tax planning measures or anything to happen from the time of the printing of the document, let's say a budget, to the time of coming into force or whenever the regulations could be developed. So given your opening statement, can you maybe clarify of why you feel that this coming into force date needed to be at the time it received royal assent, and how that's consistent with other tax policy around, you know, the publications, et cetera, and the rationale behind that?
Well, the what I talked about is the practice that oftentimes the government introducing proposed tax measures will start implementing them right away, and it is always subject to parliamentary approval. And so you may have a government that will announce it, that will start to put it in place and implement it. And down the road, you have a bill that's adopted with a date back to that date of the announcement. So that certainly can happen. In this case, there was the bill was adopted with no date, and therefore it comes into force on the date of royal assent as per the Interpretation Act.
Thank you. And so given yesterday's announcement, you see that Finance Canada has corrected any possible confusion, and the coming into force date is June 29th as established by royal assent.
The communique from yesterday does clarify that, certainly.
Thank you so much. Nice to see you again.
Okay, thank you. So we will, to finish out this this hour, we'll have 2.5 minutes with Mr. St. Marie. 2.5 minutes with Ms. Madison, and Mr. Fast, you will get the final 5. Gabriel.
Oui, merci, Monsieur.
Thank you very much, Mr. Chair. I will wait for Mr. Gerritsen to be listening to me. Thank you very much, Mark. Now, let's get back to basics. We're here because something very serious happened. Parliament adopted C-208, a very important bill. When I ran for the first time, it was the first issue that I heard about. Farmers who were saying, I'm being forced to choose between my retirement and my children who want to take over the farm. But if I sell it to them, then I won't be able to retire properly. What do I do? We've seen people from every political party bring this issue before the House. Finally, after, as I said, 527 days, we have finally managed to get it adopted. It's brought into force, and then a government press release is issued. And the government says, well, actually, we're going to bring it into force later. They announced that they are not willing to respect the will of the House. That's very serious. That is why MPs from each party asked for this emergency meeting to be held today, to say that this is serious. Now, we saw the press release that was published yesterday, just before this committee meeting. I am certain that that rectification was directly linked to the fact that this finance committee did its work properly and announced this emergency meeting. That is key. We must recall that what is voted on in Parliament needs to be respected. And the government can't pick and choose and decide not to implement certain things and implement others. This is a democracy, and that's not how things work. Now, I'm sorry, Mr. Dufresne, coming back to you. In the press release yesterday, the government announced that it would make amendments while respecting the spirit of the bill. It has made a commitment on that front. And as we've heard, it needs to go through the legislative process again. Parliament would need to adopt new legislation. Is that it? Answer, yes. Well, would the government propose a bill to the House where it says, well, no, we're going to forget all about C-208. We're just going to forget about it and tear it up. Is that something that the government could do? Could the government propose a bill which ultimately just cancels Bill C-208? Bill C-208 was adopted by this Parliament. It went through all 3 readings and received royal assent, and it is in force. So what's being discussed here is to make amendments. The idea here in this release is not to amend the entirety of the bill, or to have a bill that essentially cancels it and says the exact opposite. That would be a matter of procedure, because the question of procedure would be, can you ask the same question to the House a second time when something has already been decided on? But that's not what's being talked about here. The idea is to make amendments in the spirit of the law, but in order to correct what the government perceives as gaps.
Ms. Matheson, 2.5 minutes.
Thank you,
If
Mr.
need it.
Chair. I find it a bit disheartening sitting in this committee as a not regular member that my colleagues across the way in the Liberal caucus have brought forward past representation or past proof that ultimately the Conservative Party of Canada has a complete disrespect for Parliament. The Conservative Party on the other side has shown that now Liberals also have a complete disrespect for Parliament. And so as a New Democrat who values that power of people, Mr. Dufresne, you have said repeatedly that the power of Parliament is supreme, and that power of Parliament is determined by the people for the people. Can you just clarify once again that this is about people and the power of people, not the power of the political parties, not the power of the Liberals themselves or the Conservatives themselves, and that respect must be shown ultimately to the people and Parliament?
Well, Parliament has a fundamental constitutional role to play, and one of those roles, the 3 roles that the House plays, recognized by the Supreme Court of Canada: legislating, deliberating, and holding the government to account. And those are fundamental roles that the House plays and that Parliament as a whole plays. And I'm here to support that in the best way that I can. This as well.
Many thanks. That's my time.
Okay, thank you, Ms. Matheson. Mr. Fast, 5 minutes, and then we'll have to go to the next panel.
Well, thank you, Mr. Chair. I want to echo Mr. St. Marie's comments. We're addressing something very, very serious here. I noticed our Liberal friends were making light of this issue, but this is no laughing matter, Ms. O'Connell. This is about defiance of the will of Parliament. And Mr. Dufresne, I'm not going to ask you to make the assumption that I am making, and that is that the defiance of the will of Parliament by Mr. Trudeau will occur again under this government. This was not an oversight. And that's my real fear, is that if he's re-elected, he will move again to defy the will of Parliament, not only on this, but other legislation. So my question to you: does the government and finance department officials have any right to delay or refuse to implement legislation that is properly passed by Parliament?
Legislation that's properly passed and that is in force, and that was the issue in this case, where there's no date of coming into force that's later. It's in force as of the date of royal assent, and that becomes law. And so that is binding on the government and on citizens.
Did any finance officials or the Prime Minister's office seek your legal opinion before announcing that they did not intend to implement C-208 before amending it?
No, and nor would they, because I am the counsel to the legislative branch, not the executive branch.
Are you at all aware of whether they sought legal counsel before proceeding that way?
I'm not aware. That's not information that I would have.
All right. Now, did I hear you say that the Prime Minister could make his November 1 proposed amendments retroactive?
Legislation can be retroactive if Parliament so decides, but Parliament has to express that very clearly.
And you would agree with me that the government has signaled that it does want to make amendments and that they may be retroactive?
The government has signaled its intention to bring amendments, and it has described what those would be about. and it has talked about some application times in the communique later of either November 1, 2021 or the date of publication of the final draft legislation. And so but the communique speaks for itself on that.
So there's absolutely no guarantee from this government that it won't totally gut Bill C-208 when it gets around to amending it.
Well, we have this statement, and that's what's there. There's no other statement on that at this time.
And my Liberal friends just said there's no guarantee that pigs can't fly. Now that's the kind of disrespect that we have come to expect from our Liberal friends. Another question, what remedies do parliamentarians have to redress the government's refusal to implement duly passed legislation that is in force?
One of the roles of the House, as recognized by the Supreme Court of Canada, is holding the government to account. And so in doing this, and such as what the committee is doing or the House would do and when it is sitting and question period, is to hold the government to account and to ask questions and to require information and explanations.
Well, Mr. Dufresne, does Parliament have the right to hold the Prime Minister in contempt if he fails to implement legislation that has been duly passed through the will of Parliament?
The House has disciplinary powers over all its members, and it's up to the House to determine whether any situation would warrant using those powers.
Now, I've been a member of the House for close to 16 years now. I've never seen a government defy the will of Parliament before. You have said that you have seen there is no precedent for this kind of action being taken that we've seen reflected in the press release of June 30th. Am I correct?
The June press release was not something we had seen before.
Ever in history?
Well, we have not seen precedents in recent history, certainly since I've been here.
That is a very sad comment on our government that we, in fact, I'll just leave you with a statement, Mr. Chair. I've been appalled at the willingness of this Prime Minister to defy the will of Parliament, to challenge the supremacy of Parliament. We are going down a very dangerous road. And by the way, this opinion isn't just shared by us Conservatives. It's shared right across the board. I've spoken to Liberals who are appalled that we have a Prime Minister that is prepared to take on the supremacy of Parliament. That's all I'll say, Mr. Chair.
All right, we'll have to leave it at that. And Mr. Dufresne and Mr. Bedard, thank you very much for your advice. Number one, to parliamentarians and to this committee that we often call on you to give. And thank you for providing us with your expertise today on where we're at in terms of the supremacy of Parliament. So thank you for that, and we will suspend for a couple of minutes and bring forward our next panel. So thank you very much to you both.
Thank you.
And meeting suspended for a couple of minutes. Sylvine, welcome to our panelists, and I'll just quickly go through pursuant to Order 1082. We're dealing with Panel 2. The committee is meeting to study the coming into force of Bill C-208, an act to amend the Income Tax Act, transfer a small business or family farm or the fishing corporation. And in this first panel, supremacy of Parliament as well. With us this morning, we have, as individuals, Honourable Peter Milligan, former Speaker of the House of Commons, Honourable Don Boudria, who was a former House Leader, and are having difficulty connecting him at the moment. From the Canadian Federation of Agriculture, we have Mary Robinson, President, and is Scott Ross there as well? I'm not sure. Mr. Ross, Assistant Executive Director. And from Fédération de la Relève Acrole de Québec, Julie Bissonnette, President, and Veronica Simard-Brocou, Public Affairs. So I probably didn't get your name right, Veronica, but that's not unusual for me. So we'll start with Mr. Milligan. Peter, you're on. We'll ask you all to keep your opening remarks fairly short so we get time for questions. Mr. Milligan.
Well, thank you for inviting me to appear. I haven't done this for a long time, but I'm sorry we're not meeting in person there on Parliament Hill or in the other building that we're now meeting in, but I hope all goes well. I was interested to read about the problems with this bill in the media and hear that the government was putting in this thing where they would not allow the bill to take action until sometime next year, January 1st, I think it was. And I was somewhat surprised by this. And so it's interesting that the committee is going to come up with it. But I understand the minister's already announced some changes this morning that have possibly solved the situation, but we'll see how that goes. And I wish all of you well in your continuing good work in parliamentary matters.
Thank you, Mr. Milligan, and I understand, Mr. Boudria, you're up and running now. We'll turn to you for your thoughts. You've read lots about Parliament in your time and did a lot of it. Go ahead.
Thank you. Thank you, Mr. Chairman. I hope you can hear me correctly now. Indeed, I was interviewed by the Globe and Mail at some point a few weeks back. The reporter questioned me as to the activities of the finance department in this regard. And at first I didn't believe it. I said, well, surely you must be misreading what you're doing. And then he gave me the details. And obviously I came to the conclusion that that was improper. But contrary to what was said today, this is not the first time that finance has done this. Both Speaker Milliken and I were members in 1989 when the finance department did the opposite of what it's doing now. In fact, they had pretended that the GST was the law. They were sending out circulars, and if my memory serves me right, they had bought TV time and were advertising a tax that Parliament had not passed. And they were severely admonished by the then Speaker, John Fraser, at the time. I recall the incident. I believe I spoke about it, and Peter Milliken probably did as well, as we were both very interested in parliamentary procedure, and we're probably the last two remaining people who are non-parliamentarians who still are. But in any event, this is not something that's unprecedented, as we heard. I would gladly answer all questions later. There is the issue of the Interpretation Act. There is the Royal Assent Act as well to take into consideration here. And finally, if and when the government does move ahead with a new bill, it must be preceded by a Ways and Means motion, because what the government would be doing, should it change this to revoke the provisions of this for a certain group where they think possibly that the bill is too wide, this would constitute what is called in parliamentary jargon the revocation of tax alleviation. And revocation of tax alleviation requires a motion of Ways and Means before a new bill can be presented to the House.
Thank you, Mr. Boudria. We'll turn to Mary Robinson, Prince Edward Islander like me. Go ahead, Mary, floor is yours.
Thank you, Mr. Easter. Wonderful to be here. You can hear me all right? Excellent. Well, thank you, Mr. Chair and committee members, for the opportunity to speak to you today. As Wayne said, my name is Mary Robinson. I farm on a 6th-generation potato, soybean, barley, and hay family farm in Prince Edward Island. And I'm also president of the Canadian Federation of Agriculture, which is Canada's largest general farm organization, representing nearly 200,000 Canadian farm families from coast to coast to coast. I will start by thanking the committee for convening so quickly and by expressing my appreciation for yesterday's announcement from Minister Freeland, ensuring the uncertainty around the coming into force of Bill C-208 has, for the time being, been put to rest. Modern agriculture is capital intensive, with millions of dollars in capital assets involved in the transfer of most farm businesses these days. Bill C-208's passage ensures that each of these families who own one of the 50,000 incorporated family farms in Canada can finally access the lifetime capital gains and capital gains treatment, avoiding potentially hundreds of thousands of dollars were this inequity to persist. While it's commonplace for a farm transfer to involve millions of dollars in capital, nearly all of this is tied up in productive assets that are essential to the maintenance of the farming operation into the next generation. Meanwhile, the retiring farmer needs to fund their retirement from the proceeds of a sale, and the next generation almost assuredly lacks the capital to buy the assets outright. Every dollar matters, and a smooth intergenerational transfer is critical to the financial health of both parties. For a sector that is almost wholly family-owned, the impending transfer of tens of billions of dollars in assets across thousands of family farm transfers has bearing on the outlook of an entire industry that is key to Canada's short-term economic recovery as well as Canada's long-term growth. Family farming is recognized internationally for sustainable growth, environmental stewardship, and a connection to one's community, seen through increased spending in one's local community. It also contributes directly to the vibrancy and social fabric of rural communities across this country. The long-standing unfairness that C-208 has addressed had been a disincentive to passing these operations to the next generation and maintaining this way of life for thousands of incorporated family farms across Canada. For those that still wish to do so, they face undue additional tax liabilities that could very well be in the hundreds of thousands of dollars. Following the bill's royal assent, we were disappointed to hear that farmers and financial advisors were left uncertain as to the status of the bill's implementation, and are pleased to see yesterday's announcement provide some additional clarity, both for the immediate future and for the government's longer-term plans in this regard. I would like to take this opportunity to applaud Parliament for passing Bill C-208 and resolving this long-standing inequity facing Canadian farms, and welcome this committee's efforts to ensure there is clarity moving forward. If further measures are needed to address undue tax avoidance as outlined in yesterday's announcement, we would implore Parliament to ensure the intent of this bill maintained, grandfathering family farms access to capital gains treatment for the transfer of incorporated family farms. Such access can easily be limited if undue administrative burden or significant costs are reintroduced into the system. Based on extensive consultations with farm advisors since 2012, when CFA first called for a resolution of this inequity, we believe the targets for future amendments can be addressed while maintaining this access for Canadian farm families. However, we believe this can only be assured through dialogue with farmers and farm advisors. The potential for unintended barriers is significant, unless informed by those with direct experience managing farm succession and financial planning. In 2018, CFA actually convened roundtables of farmers and farm advisors across Canada to discuss this subject with Finance Canada officials and inform their work on this very topic. We will be pleased to facilitate similar engagements again to ensure any future legislative amendments respect the realities of modern family farm transfers. In conclusion, we call on the government and Parliament to ensure the Inequity Bill C-208 resolves is not reintroduced, and that Canadian family farms are never again disincentivized from selling to the next generation by the Canadian tax system. I thank the committee for its time, expediency, and commitment in seeking to provide clarity around C-208's coming into force. Thank you.
Thank you, Mary. Turning to Ms. Bissonnette, President, go ahead. The floor is yours.
Merci. Donc, bonjour.
Thank you very much. Thank you, Mr. Chair. Hello. Thank you for having invited us to share observations regarding business transfers. My name is Julie Bissonnette. I'm a dairy producer and president of the Fédération de la Relève Agricole du Québec. And I'm accompanied today by our public affairs coordinator, Véronique Simard-Brochu. We already introduced ourselves last time, but as a reminder, our organization brings together youth from 16 to 39 who care about agriculture, and we represent more than 1,700 members throughout Quebec. And today, we are here to talk about the confusion regarding the application of the tax measures in Bill C-208. To start, here's a quote from our previous appearance at the Finance Committee. The next generation of business owners has been speaking out about the problem for more than 15 years, and hopefully this time the matter will be fixed once and for all. So I think that quote sets the table for today. As we have already mentioned, farmers' average age is now over 55. So it is urgent that we take action for the farming community. For future transferors, 70% of them would like their business to stay in the family. So this is the ideal way to carry out a transfer, especially when we know that this type of succession is 6 times more likely to succeed than an external transfer. After the adoption of this bill in both chambers and royal assent on June 29th, we were finally able to celebrate this victory. But there was a great deal of confusion after the announcement from the Department of Finance on June 30th, which seemed to imply that the application of the law would be delayed. We were very pleased to see yesterday evening that the same department finally ended a month of confusion by offering clarifications for farmers. As the department stated, the amendments to the bill now have force of law, which responds to our biggest question. It means that family farm transfers now have a right to the same tax benefits as a third-party transfer. However, we would appreciate having the department clearly say that if a genuine family transfer now occurs between now and the adoption of the potential future legislation, the transfer will still benefit from the same tax situation and will not be penalized. The government should be clear on that point so that accountants and financial advisors can freely advise their clients about their business transfer without fearing that they're misleading them. Perhaps you could ask them that question this afternoon. We need this type of clarification. The department did the right thing by offering some answers yesterday. We believe that any changes to the tax system is serious, and these changes should not be made through press releases, not only at any rate. That is why the right thing to do is to simply allow the present legislation stand and then make future amendments in a future bill, as was explained yesterday. For the next steps, we understand that the government's intention is to make farm transfers easier while protecting the tax system. Future amendments, according to the press release, would ensure that the legislation facilitates genuine intergenerational transfers and is not used for, that these changes are not used for artificial tax planning purposes. We don't see any issue with that as long as that enables genuine intergenerational transfers to occur within families. We would encourage the department and MPs to draw inspiration from the Quebec legislation, which has created criteria to ensure that these family transfers are genuine. However, it is crucial that the intentions of Bill C-208 be maintained so that no parent be discouraged from selling the family business to their child because of the tax system. And there's something else to consider. Transferring a business is a major step. There are many things to take into account. It's not simple, and each transfer is different and unique. So there is no one size fits all solution. We need to keep that in mind when we are establishing future criteria. We do not want to replace the previous unfairness to be replaced by new obstacles. In conclusion, we would like to repeat that we appreciate that the department has made clarifications, and we are impatiently looking forward to future proposals. Meanwhile, it is nice to know that this legislation is enforced after the confusion of the last few weeks. I'd like to thank the members of the committee for having invited us to share our experience on the ground. Thank you.
What does those events say about the state of Canadian democracy and the role that our executive branch plays vis-a-vis the legislative branch? And I'd be interested in your the comments of both of you.
Mr. Milligan, do you want to start?
Okay. I'm not sure how this all began, and I assume this was not a cabinet decision to suspend the bill's immediate application. I assume it was something that was recommended to them or dealt with by public servants who said, we don't want to do this right away. We can delay this for a while. And I just don't think they thought about the legal implications of it, because I think they thought they've done it before with government bills, because often the bill may have words in it that allow them to do such a thing. But this was passed and became law, and I think it just should have been automatic, and that's the impression I had. But I haven't followed this closely or anything. But I'm delighted they've changed their position and are now going to allow it to go into effect immediately, which I think is what you have to do with an act of Parliament.
Mr. Boudria.
Yeah. First of all, I don't believe there was ever an order in council passed in order to change that effective date. So I don't see that it could have been a cabinet decision or anything like that.
Right.
What seems to have happened here, and I'm only going to give you my impression, is that there's a lack of knowledge of how Parliament works inside several government departments. Do these people who made that decision know that there's such a thing as the Royal Assent Act? Do they know that there is such a thing as the Interpretation Act? Do they even know that bills come into force automatically on Royal Assent if there is not a proclamation or a coming into force clause in the bill? And finally, when the official from Finance Canada was interviewed by the Globe and Mail reporter, they seemed to make a difference or a distinction between coming into force. No, the word is the commencement date and the implementation date. In their view, there was a difference. And to me, that's like saying that your birthday is different from the day that you were born. I mean, this is ridiculous. They're euphemisms, and everyone knows that. And finally, what was the intention of Parliament? If Parliament had wanted this bill to come into force later, it would have said so in the bill. Similarly, if Parliament had wanted to have a specific date that was not the date of Royal Assent, that too could have been in the bill. So in other words, there were two occasions where that could have been put in the bill by the drafter of the private member's bill in question. I don't even think we should call it a bill anymore. It's not a bill now. It's an act. It's actually part of the statute law. So, but anyway, the law as amended, which is now what it is, it reads the way it does because that was the intention of the legislator, capital L. If the legislator had wanted it otherwise, the legislator could have done so, but did not. And if finance says, well, you know, the legislator made a mistake, well, that's the legislator's entitlement to make such a mistake. And if they want to correct it, they can. As I said, though, because they're revoking tax alleviation, they'll have to present to the House first a motion of Ways and Means, and then subsequently, that motion of Ways and Means, by the way, has to be concurred in by the House, and only then will you be able to introduce the bill because you're revoking tax alleviation that was provided for in this bill. So not implementing it never was in the cards.
Thank you, Don. We'll have to go to one more question for Mr. Fast and then move ahead. Go ahead, Ed.
Yeah, I've already said that my fear is that this may happen again, that either the Prime Minister's office, cabinet, or maybe finance officials on their own. We don't know who directed who in this case, but my fear is this will happen again. So my question to both of you, if this happens again, what are the remedies that parliamentarians have to ensure compliance with the rule of law?
Mr. Boudreau, we got you on screen. If you can be fairly quick, we're going to rapidly run out of time. Mr. Boudreau and then Mr. Milligan.
Okay, well, very quickly, I do think that notwithstanding what happened yesterday, this should still be raised in the House. And having it raised in the House, the Speaker will be able to rule on it and assert the Parliament's authority. And essentially, that is what is required. Whether the Speaker will choose to do that or not, or whether he'll say that now it has become a hypothetical question because the press release in question was replaced with a different one that seems to respect the authority of Parliament, well, the Speaker will have to make that decision on his own.
Milligan, anything to add? Rachel. You're muted, Peter.
Sorry, Don, I think Don's comments are absolutely correct. The Speaker can make a decision on these matters if it's raised there, but whether it would get raised is another issue, but they do come that way occasionally before the Chair, and the Chair can decide whether Parliament's privileges have been breached by this kind of action, and I think it probably would have been decided that way. That's my guess, anyway.
Rachel, Ms. Bendayan, 5 minutes.
Thank you very much, Mr. Chair, and let me begin by thanking you as well, both as chair and as member of our government's caucus, for your leadership on all things related to finance, and in that vein, also for calling this meeting of the Finance Committee at the end of July when the House isn't sitting, in order to clarify matters in relation to the coming into force of Bill C-208. And like others have said, I believe you are a giant in the House of Commons, sir, and a mentor to so many of us. So I would like to thank you. It was mentioned earlier this morning, further to questions from different members, and I would like to really unequivocally confirm on behalf of the government that any amendments to safeguard our tax policy or to avoid artificial tax planning in connection with Bill C-208 would not be retroactive. As stated in the press release of yesterday, new proposals would apply as of the later of either November 1st, 2021, or the date of publication of the final draft legislation. I hope that clarifies matters for my friends and colleagues. Je tiens également à ajouter ma voix à...
I would also like to add my voice to those of previous stakeholders and underscore the importance of parliamentary authority And so my first question is to the two organizations that are here representing our very dear agricultural sector. Thank you for being here today. As Parliamentary Secretary to the Minister for Small Business, I really care about this issue of intergenerational transfer. We know that many farms are small businesses. Looking at a 2016 survey, about half of farms are independent businesses, and an entire quarter of them are family businesses. Our government has shown that we are here to support small businesses in all sectors, including the agricultural sector. And we believe that we know that there are 200,000 such businesses throughout the country. $1.4 billion have been spent during the pandemic for the agricultural sector through the wage subsidy, and $50 million in the agricultural sector for rent assistance, $5 billion in additional funds, as well as $55 million for agri-recovery to help agricultural producers affected by COVID, and a great deal of other assistance as well, for example, in disposing of unsold product. I have a question then on C-208. Now that we have clarified that this bill is indeed in force and has been since June 30th, what are the biggest issues that you are facing today from a tax perspective? Ms. Bissonnette, you have mentioned that these transfers can be very complicated. Perhaps we can start with you, Ms. Bissonnette. Do you have suggestions or concerns about the tax system that you would like the government to know about? Thank you for the question. When I said that these transfers are complicated, I meant that they're complicated on every level. On a human level, on an economic level, there are many obstacles, and every situation is unique. It's very hard to come up with a single silver bullet answer. So that's more what I meant. And the more the farm is worth, the more complicated it can be. And so ultimately, when you're transferring your farm, it's a huge step, because agriculture is a way of life, it's a passion, so transferring your farm to someone else is major. But at least if the government removes this current obstacle, as has been done and over the past month and as was confirmed yesterday, that will at least remove one of the major obstacles to these farm transfers. Thank you very much, Ms. Bissonnette. And now Ms. Robinson.
Thank you for the question. You can hear me okay? So I believe the question was what more could be done in regard to tax? What are the more complicated things we face in tax? Is that correct?
Yes, that's correct, Mary. That's correct.
Thank you, Wayne. I'm having feedback. I think probably what government could do at this point in time to help farms would be, obviously, our big concern was this intergenerational unfair tax situation we had, which has been addressed, which we now have an act. As Don has pointed out, it's no longer a bill. I think moving forward, what we would like to see is things like a grocer's code of conduct. We would like to see improved BRM and other measures put in place to help strengthen the family farm, so that we can, if people want to avoid amalgamating and trying to capture those economies of scale, that we can better ensure the margins that farmers are able to capture. As we've said, it's a capital intensive investment, meaning that so much of our money is tied up in land, equipment, and buildings that it means that we have a lot of skin in the game. And as you look through the value chain of our food system, we seem to be at the tighter end of the margin scale. So I think if government could have a more favorable look in what they do to ensure that farms are on sure footing financially, that would ensure that the next generation feels the confidence to take on that investment of millions of dollars for most family farms.
So we will. end that round there and go to Mr. St. Marie, just to mention BRM for the benefit of committee members. Larry and I may know for sure, but it means business risk management. Go ahead, Mr. St. Marie, followed by Ms. Matheson.
Oui, merci, Monsieur le Président. Alors,
Thank you very much, Mr. Chair. I'd like to greet all the witnesses. Thank you very much for your fascinating remarks. I will start with a comment for Ms. Bissonnette. Thank you very much for your remarks. You had a question that you said we could even ask the public servants this afternoon. And I am pleased to say that we actually got an answer from Ms. Bendayan, who on behalf of government committed to businesses that will be carrying out family transfers that the subsequent bill that will make amendments to Bill C-208, that it will not be retroactive. That is the government's commitment. And I would like to thank the government for this commitment that Ms. Bendayan has just passed on. Thank you for that. Now, before moving to questions, I have a comment to make in regard to the conversations we've heard so far in this panel. Upper officials, even if upper officials in finance have doubts about the implementation and coming into force of this bill, in my opinion, that doesn't excuse anything. We heard just now from Mr. Dufresne, the parliamentary law clerk. As everyone here knows, when there is no implementation date in a bill, then it's the day that it receives royal assent that it comes into force. And Mr. Dufresne reminded us that the government, the Minister of Finance, the Prime Minister, they reminded us that they depend on the Department of Justice for counsel on this issue. There's no better source than the Department of Justice in order to get legal advice. And we all know that when there's royal assent, that's how it works. And if the government didn't know that, it's no good to say that people weren't aware. The minister is accountable. The government, should be accountable. They can't pretend to be as innocent as babes. No, on the contrary, they cannot be excused from not knowing this. As we saw in a Radio-Canada article yesterday, between first reading of this bill and royal assent, 527 days passed, a year and a half. At each stage, first reading, second reading, third reading, report stage, committee study, the government could have made amendments. If it had really been serious about this issue, the government could have said, for example, that it is concerned about tax evasion. Well, absolutely, that's an excellent concern. But then why did the government allow 527 days to go by? And then now it suddenly says, oh, well, we're just going to create a new bill after the elections, perhaps, which leads to more uncertainty. And then they say they're going to modify the legislation. It's all very well, and they're just pretending to be innocent in all this, but it's really unfortunate. Now, a last comment before my questions. Yesterday, a press release corrected the situation, and Ms. Bendayan, who speaks on behalf of government, has confirmed that the bill has been saved and it is in force and it will be applied. And I would like to congratulate all members of the committee because, in my opinion, it is the fact that this emergency meeting of the committee was called that has enabled this to happen. And I would like to tip my hat to Wayne Easter, the chair of the committee, for having allowed us to sit. It will make a real difference. I have a question for Ms. Bissonnette. I really enjoyed your remarks. 70% of Quebec farmers would like to pass on their business to their family. You have a dairy farm. How much does the average dairy farm cost? When you think about the animals, the grain, how much does that cost on average in Quebec? Well, we're talking millions. Millions overall. Okay, you say it can cost millions of dollars. So if a parent wanted to pass on this farm to their child instead of a stranger, how much did it cost them? Well, a lot of people contacted me after June 29th, And they said it might easily cost up $200,000 to pass on the farm to your family. The effect of this legislation was to the tune of $100,000. So ultimately, previously, you were giving up hundreds of thousands of dollars, perhaps, by selling the farm to your family. Is that it? And this bill is going to correct that. You've been pushing this issue for 15 years. When I initially ran, this was the first issue that was brought to my ears. Farmers and SMEs were really pushing this issue. We really need to do something about this. Thank you very much. I'm so glad we're finally making a difference.
To Ms. Masson will be followed by Mr. Berthold and Mr. Kelly on a split. Go ahead.
Thank you, Mr. Chair, and thank you to the witnesses. We've heard a lot of statistics. The ones that I wanted to ensure are there is the fact that over the last decade, 8,000 family farms have disappeared. The average Canadian farmer has seen their debt double since about 2000. The last stat that I could see was in 2019. That debt is about $106 billion. And that's quite significant. If both Ms. Bissonnette and Ms. Robinson could talk about how that impacts their members specifically, that plan for retirement. Certainly there has been a great deal of stress during COVID on those family, small businesses, and what that additional stress has caused. Ms. Bissonnette, if you wanted to go first, I guess.
Go ahead. Who's going first?
Oui, merci pour la question. Donc, comme je vous disais tantôt, là, c'est ça. Le transfert de ferme en général, c'est déjà une période assez stressante. C'est sûr que avec l'incertitude qu'il y a eu au cours du dernier mois, ça n'a pas non plus aidé. Là. C'est pour ça que je répète encore qu'on est très heureux d'avoir eu la clarification hier soir. Fait que, au niveau de la relève, c'est pas mal ça.
Just if I could interrupt Ms. Bissonnette for a minute, we're not getting a translation, or at least I'm not. Can we check the translation?
Apologies, the interpretation rather should not be working.
That special mic that Parliament sent you. Okay, try it now.
Oui, est-ce que ça fonctionne?
Is that working? So regarding the concerns, well, it's true that in the last few weeks, it added a certain level of stress because we have the pandemic, the droughts, the temperature. There were a lot of stressors for our agricultural producers. And so this did add something, but we were very glad yesterday to see that things were being clarified. That did clear up. At least it reduced one stressor over the last month that we had.
Same question. Mary?
Thank you. Thank you for the question. I think in regard to the stresses that people feel on farm right now, there are so many and they're so varied, and just the very nature of agriculture in Canada, it's incredibly diverse, both in size of farm operations as well as the commodity that they're producing. Generally speaking, what we want to see, what we advocate a lot for at CFA is improvement to the business risk management program so that farmers have a financial backstop, so that they don't have this overwhelming stress that when something comes along that's well beyond their control, that they're going to lose everything. Because it's an interesting combination. I'm sure Mr. Chair could speak to this, the combination of tradition, of multi-generations, of being viewed as a steward of the land and the environment in your community. And it's a high stress situation all on its own. So when we see just in recent years, we've seen geopolitical issues, we've seen transportation issues, we see climate issues, we see carbon tax potential, we see many things that are being downloaded to farmers. Farmers ultimately are price takers because we produce commodities and very rarely do we have opportunity to influence the price we're being paid. So our government needs to ensure they make sure our foundation of our food system is well shored up, is well positioned, so that the next generation of family farms can come along and do an exceptional job.
Last question, Matheson.
So a lot of that farmland that we talk about, that protection of sustainable farmland, the environmental consequences, of course, a lot of that has been lost over the years. Urban sprawl, again, we speak of that debt from a lot of your members. And of course, what this bill could do to protect against foreign interests taking over and redeveloping that land, ensuring that it's protected from that urban sprawl, is ultimately one of the key bases of this bill. Could you talk about what your members are facing in terms of that as well, and how this bill specifically can protect against that foreign investors taking over and redeveloping?
You want to start, Mr. Robinson, then we'll go to Ms. Bissonnette.
Thank you, Mr. Chair. I think ultimately there are no farmers that I'm aware of who would sell their land if their farm was profitable. And I think that one of the best things we can do to prevent the loss, the erosion of arable land in this country would be to ensure that farms are profitable and they have a financial backstop. Farming is a way of life and it's a business. It's an interesting mingle of the two. But ultimately, farmers carve off and sell land because of economic pressures, in my opinion.
Ms. Bissonnette?
Oui, merci pour la question.
Thank you very much for the question. It's interesting because for the next generation of agricultural producers, access to land and climate change is going to be part of our everyday considerations. We know that when it comes to climate change, as we often say, we are part of the solution in agriculture. We take care of our land and we need support. As Mary was saying earlier, we need support so we can be profitable. It's all very well to say agriculture needs to do this or that, but we need support in order to be able to accomplish things. Regarding access to land, that's a big issue, and we don't necessarily have the solution, because if there were a perfect solution, well, we'd already know what it was, but we will continue to promote access to arable land for future generations. And we will continue to try to conserve our land. That is Canada's wealth, our remarkable amount of agricultural land. This will definitely be an issue in the years to come. Thank you.
Thank you. Thank you all. We'll turn to Mr. Berthold for about 3 minutes. Same for Mr. Kelly, and then Ms. Surowitz will wrap it up. Mr. Berthold.
Merci beaucoup, Monsieur le Président. Monsieur le Président.
Thank you very much, Mr. Chair. Perhaps because I'm not a regular member of the committee, I cannot share my colleague from the Bloc Québécois enthusiasm regarding yesterday's press release and my colleague Ms. Bendayan's comments. Bill C-208 was voted on by Parliament, and yet all members of Cabinet voted against Bill C-208. Then a press release was issued by the Department of Finance to say that Bill C-208 would not be applied until January 1st, 2021. I've been a chief of staff in the past, and what I can say is that such a press release is not issued by the Department of Finance without someone in Cabinet having seen and approved it. Because this is a major issue when it comes to finances, and as well as the application of a piece of legislation that was voted on by Parliament. And as someone who is familiar with how Cabinet works, well, I can say that this wouldn't have happened without approval. Now, I have a question for Ms. Bissonnette, who I've met many times before, and I would ask her whether today she would be willing to recommend unhesitatingly to a family that they'd move to transfer their farm to a family member, knowing that amendments have already been announced by the government. I'd like to thank Mr. Berthold for the question. As he said, the last few months have been difficult, and this did add a stressor, as I was saying earlier. But getting that confirmation yesterday did help. And for now, we have got a confirmation that the legislation has been applied and that it's currently in force. Of course, every situation is different. Every situation is unique when it comes to a farm transfer. But given that this legislation is supposed to have entered into force and we have that commitment, well, We will be following things closely, but for now, we did get that confirmation yesterday, as well as the confirmation this morning regarding that small time period between the two releases. But we think that the matter is settled for now. But do you think that the government should be clearer in writing and give you clearer indications, not just words in a press release? We're talking about hundreds of thousands of dollars for transfers or for people who want to buy the farm. These are huge sums that are at stake. There's a lack of certainty here. There are gaps. And that might lead some farming families to decide to wait because they're not sure what to do. Previously, for example, in supply management, the government previously promised that it wouldn't affect the sector and that the sector would be compensated. And yet today, we see that we have no idea when the sector will be compensated for the U.S. trade agreement. So don't you think that this is adding uncertainty, a level of uncertainty that was completely unnecessary? It's true that the June 30th statement did not help. Yesterday's did help. But from our perspective, once royal assent was given, well, the matter was settled. We know that the bill came into force when royal assent was granted. Of course, it's not ideal that these kinds of decisions be made via press releases, but at least now we can know that the matter has been settled.
To Mr. Kelly, Pat, you're up.
My question is for former Speaker Milliken. Thank you for your service to Canada during your long tenure as Speaker. During your time, which spanned two governments, two prime ministers, did the government of the day during your time as Speaker ever sue the House of Commons and name the Speaker of the House in a lawsuit against the House of Commons?
Point of order, Mr. Chair. I'm certainly defer to you on the rules regarding relevance, but I believe that this meeting was called to discuss the coming into force of C208.
Speaking to the point of order.
What's your thought on the point of order? Go ahead.
The topic of the meeting is of this panel was the first meeting today was on the authority of Parliament.
Okay, I'll let the question go.
Thank you.
I don't recall any such lawsuit when I was there. No.
So, does it concern you that the government would sue the elected members of the House over their authority?
I can't imagine how they could if they've exercised their authority properly.
Yeah, they have done so. Anyway, Mr. Chair, if this is indeed the last panel, I will maybe let Mr. Maguire get a question in. I think I've got a minute and a half left.
Okay, Mr. Maguire.
Well, thank you very much. I want to thank Mr. Boudreau and Mr. Milliken, honors for your clarity today as well. But I want to ask a question of Ms. Robinson and Ms. Bissonnette. The press release that was put out yesterday, after 527 days, as my colleague from the Bloc said, of fighting this bill, and 20 days to have said earlier that, if it was such a good bill, why didn't they vote for it in the House? The word clarifies taxation for intergeneration transfers of small businesses is the caption in the of the department's press release from the Deputy Prime Minister, not there. So they're acknowledging that it's law, and everybody knew that except their own caucus. So I think it's nothing new to say that. I just want to use, but there's still doubt here, and I've already had phone calls on that because, they're saying, well, we know it's law now, but the release also says forthcoming amendments are intended to make sure that it facilitates genuine intergenerational transfers and is not used for artificial tax planning purposes. So the word genuine, I want to ask my colleagues in the agriculture field, because this applies to all small businesses, which, the government wanted to remove the other 97% other than farming and fishing from the bill in the Senate in that regard. The word genuine leads me to believe that the government doesn't believe that a lot of these transfers are genuine, that there may be some hidden agenda behind them and not used for artificial tax planning purposes, when the government, they know full well that CRA can audit anyone at any time. So the questionable part of this whole thing about introducing amendments and introducing the bill, it also states that these would apply as of the later of November 1st this fall, or the date of publication of the final draft legislation. So my question to you is, do you think this will ever happen? I mean, the later could be another 2 decades away, or 6 years, or 4 years. I see this as a very open-ended opportunity for the government to continue what they've done for the last 6 years. Nothing in this regard. And I think that that's also the 4 points that they've got in this statement that they put out yesterday also lead to a great deal of misunderstanding by the government, in this particular case, not the finance department, about how these businesses are the same as any other small businesses, that farming and fishing are the same as any other small business. They're talking about stripping of wealth in these small businesses, but they're only referring to that if it's a family farm or a family business, not one that's sold to a complete stranger. So these things are very concerning to me as a former farmer and farm leader in Western Canada, and in Canada for that matter as well. And I just wondered if you could comment on those.
We're getting into the details of the bill. I would say, Mr. Maguire, if you go back and look at the record on Ms. Bendayan's words, I think that was spelled out pretty clearly there from a government perspective, so that'll be in the record. Who wants to take a stab at that question?
I will, Wayne.
Okay, go ahead, Mary.
Well, I think absolutely, Mr. Maguire, you're correct that it's not black and white. It's still a little bit gray, and it certainly causes me concern. The question asked earlier of Julie on if there be confidence in telling someone to move ahead immediately with a transfer intergenerationally. I personally would be quite nervous of it. I think we heard Mr. Boudria speak to the idea of November 1st or the later publication, and I am not a parliamentary expert by any means. I'm a farmer, and I rely on my financial advisors, and I hope that there's great clarity given to accountants as they guide these multi-million dollar transfers that happen with the implication of hundreds of thousands of dollars in taxes to be paid.
Okay, thank you for that. And we'll turn to Ms. Sirowitz for the last round, and then we'll adjourn until the next panel later this afternoon with Finance. We should be able to get some clarity then. Ms. Sirowitz.
Thank you so much, Mr. Chair. And if you could just maybe... my colleague, Mr. Garretson, would like to speak for the last minute of my question. So if you can make sure you cut me off, as well as the answer.
I'll cut you off at 4 minutes.
Okay, no problem. Well, then I have a lot of time. So I just want to say thanks to you for convening the session today. Thanks to all my colleagues for making it out today. It's actually nice to really see people in person. It was quite clear from the news release that was put out yesterday by our government that we're committed to implementing 208, and we're also committed to protecting the integrity of the tax system. And so my question is both to Ms. Robinson as well as to Ms. Bissonnette. So as we are intending to bring forward these amendments, what messages would you send to the federal government as our officials are actually working on these amendments? So that's the first part. And the second part, Ms. Robinson, you made a very clear plea to make sure that officials connect directly with the grassroots farmers. Are there any other groups we should make sure to touch base with? So maybe we could start with Ms. Robinson and then follow with Ms. Bissonnette, and then we could maybe transfer whatever time I have left to Mr. Garretson.
Thank you for the question. I think in regard to grassroots consultation, we represent farmers, and I probably shouldn't speak for industries outside of farming. I'm not familiar with them as I am with agriculture, but I think it's incredibly important for government to speak with farmers and understand, because it is such a capitally intense investment that it's perhaps not very well understood by people outside of agriculture, and sometimes in particular by people who who live in large urban centers, which seems to be most of government and bureaucrats. So would appreciate great consultation with our members on that. And at this point, I would defer to Scott Ross to speak on the other points, if that's okay.
Go ahead, Scott.
Yes, thank you, Mary. And to the question, I think one of the messages we would convey is that succession, and I think Ms. Bissonnette said this earlier, is not a clear-cut, one-size-fits-all process for Canadian farmers. And so why we highlighted the need for dialogue is that it is a very complex process that can take a lot of different forms. And so it's not really a matter of just answering a couple questions and ensuring those are respected, but having a very engaged dialogue, not only with farmers, I'd suggest, but also with the myriad of farm advisors that are involved in succession planning, everything from succession planning specialists to accountants and legal counsel as well, because this is a very involved process with a lot of capital involved, as Mary said. And so I think it's about getting all the right voices in a room and making sure that all those perspectives are informing that discussion.
Did Ms. Bissonnette want to add anything?
Oui, merci.
Thank you. I agree with Ms. Robinson and Mr. Ross. We've seen that in Quebec, criteria have been set and things seem to be working well. We haven't heard anything to the contrary, so perhaps that's someplace that could serve as inspiration. We've heard that from the beginning of consultations on Bill C-208. And also, as I was saying earlier, farm transfers shouldn't be affected by the criteria because clearly the goal isn't to commit tax evasion when you're transferring a farm business. So we hope that these guidelines won't create new obstacles.
Okay, thank you. I should add as well here that I know we didn't have room for another witness.
Mr. Chair,
Dan,
do I still get the last minute there?
Yeah, you get the last minute. I just want to add on this point because we've heard from the agriculture sector, but I do know Dan Kelly from the small business sector had asked to come before the committee, but we couldn't handle a fifth witness in this panel. And I'm sure he and the fishing community as well would be saying that they absolutely have to be consulted as well on any on the points outlined in the press release going forward. So I just don't want that to be lost because we just have agriculture here. So that has to be assured as well. So Mr. Gerritsen, you've got a little over a minute, about a minute and a half.
Thank you, Mr. Chair. My question is for Mr. Milliken. I'm a big fan of your work, Mr. Milliken, and your work has come up a couple times in this room today, in particular in discussions around parliamentary privilege and finding Parliament in contempt. And so in that vein, and following on the questions of Mr. Kelly, I want to go back to a ruling that you had. You ruled that Parliament back in, I believe it was 2010, and I'm reading from the Canadian Press here. Milliken ruled Parliament had a right to order, this is, in regards to the breach of parliamentary privilege over the Afghan detainee documents. And you ruled that Parliament had a right to order the government in December to produce uncensored documents to members on a special committee examining allegations that detainees transferred to Afghanistan custody were tortured. You said that the order was clear and procedurally acceptable, but acknowledged that it had no provision to protect sensitive information within the material. And here's where your ruling differed from one that has been referenced recently in this committee that occurred recently in the House of Commons. You said specifically during the lengthy ruling that you called on House leaders, ministers, and MPs to find a, quote, workable accommodation, end quote, to satisfy all parties, quote, without compromising the security and confidentiality contained, end quote. You made it very clear that you respected, and the House respected, that confidentiality that was a requirement through other statutes and other laws. And you saw the need to encourage members to find accommodation. And in fact, recently, when a similar situation happened in front of the House House of Commons, the House Leader, Mr. Rodriguez, stood up and tried to find accommodation, yet there was no willingness to see that from the other parties. I'm curious if you can comment as to why you thought it was so necessary to have that accommodation seen and to find that compromise so that that confidentiality could have been protected.
Mr. Milligan, we'll allow the question because we've had it from both sides. So if you could give a fairly concise answer to that question, and then we will adjourn to the next panel.
Well,
Mr. Milligan.
I agreed. I thought the thing to do is to have these documents reviewed by a panel of members in secrecy, so they could choose which ones should not be made public because making them public would cause a breach of national security. That was the purpose of it. And my understanding was the group met in private and in secret. They were sworn to secrecy and they did some of this work, but I never had the results. Parliament got dissolved before they ever announced anything from their findings. So I never heard a word. I don't know what happened. Parliament was dissolved, so the Speaker's ruling went out the window. When the new Parliament met, that was another issue, and it wasn't raised as far as I'm aware. But then I was gone, retired. So it was just one of those things that happened, and because the members were sworn to secrecy, when I would ask one of them, what's going on? Are you having meetings on this? Can't tell you anything, sir. We're sworn to secrecy. I just don't know what happened, and I never did hear it. Okay.
Thank you for that, former Speaker Milligan. We're getting into a little parliamentary history here, and that doesn't hurt any of us, that's for sure. So, with that, look, thank you to Ms. Bissonnette, to Ms. Robinson, and the people with you both, and to Mr. Milligan and Mr. Boudia. Thank you for appearing today and answering our questions and having a bit of a lively discussion by times. With that, meeting adjourned.
Thank you.
Thank you.